Of the 25 castes, only 9 are scheduled castes throughout the state. The criteria used to identify the scheduled castes itself indicates that the endeavor was not to include all castes that suffered from identical forms of untouchability. The state, in exercise of the power under Articles 15.4 and 16.4, can further classify the scheduled castes. The first prong of the test for subclassification is whether the scheduled castes form a homogeneous group, integrated class, for all purposes. We have held above that even if Article 341 creates a deeming fiction, the provision does not create an integrated class that cannot be further subclassified. The provision only puts certain castes or groups or parts of them into a group called the scheduled castes. The castes or groups within the scheduled castes form an integrated class for the limited purpose of constitutional identification. They do not form an integrated class for any other purpose. We have also established through historical and empirical evidence that the scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. Thus, the first test is satisfied. The state, in exercise of its power under Articles 15 and 16, is free to identify the different degrees of social backwardness and provide special provisions such as reservation to achieve the specific degree of harm identified. If the scheduled castes are not similarly situated for the purpose of the law or the specific harm identified, there is nothing in Articles 15, 16, and 341 which prevents the state from applying the principle of subclassification of the class. Thus, the scheduled castes can be further classified if A, there is a rational principle for differentiation, and B, if the rational principle is a nexus with the purpose of subclassification. The scope of subclassification of the scheduled castes is summarized below. A. Since the purpose of Articles 15.4 and 16.4 is to ensure equality of opportunity of the socially backward classes, the criterion for subclassification within a class, be it the other backward classes or the scheduled castes or tribes, must be an indicator of social backwardness, and B. Since the state can use any yardstick to determine inter se backwardness, it is not necessary that the criteria for subclassification and the criteria used to distinguish the class from the other classes must be the same. That is, if the criteria for recognizing the scheduled caste as a backward class is untouchability, it is not necessary that the group can be subclassified only if there is inter se backwardness due to the same identity, that is untouchability. The course of action adopted by the state is subject to judicial review when faced with a constitutional challenge. Where the action is challenged, the state will have to justify the basis of its action. The basis of the subclassification and the model which has been followed will have to be justified on the basis of empirical data gathered by the state. In other words, while the state may embark on an exercise of subclassification, it must do so on the basis of quantifiable and demonstrable data bearing on the levels of backwardness and representation in the services of the state. It cannot, in other words, merely act on its whims or as a matter of political expediency. The decision of the state is amenable to judicial review. A, the objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. B, the state must collect data on the inadequacy of representation in the services of the state. The inference in Nagaraj that CADA must be taken as a unit to determine inadequacy of representation, inadequacy of reservation, based on the observations in R.K. Savarwal, in our respectful opinion, is misplaced. The CADA as a unit was considered only for the purpose of preparation of rosters to draw a balance between the reserved and open seats. This court did not hold that the CADA must be used as a unit for the purpose of determining the adequacy of representation. And C, conventionally, the state has assessed if the class is adequately represented by comparing the representation of the class in the services to the total population of the state. However, adequacy of representation, when determined purely from a numerical perspective, without accounting for factors such as representation vis-a-vis posts, would dilute the purpose of the provision. The objective of Article 16.4 is to ensure effective representation of the class in the services of the state across posts and grades. Classes which are socially backward occupy the lowest of the social strata, primarily because of the traditional occupation accorded to the class by social rules. For example, certain Dalit castes are regarded as scavenger castes. Even with the provision for reservation, it is very difficult for the backward classes to shed the traditional occupation that is ascribed to them by society and optimize the opportunities even at the lowest levels. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Thus, for the above reasons, The holding in Chinaya that subclassification of the scheduled castes is impermissible is overruled. The scope and limits of subclassification of the scheduled castes shall be as prescribed in the judgment. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate.
Oblate to not.
Just, what's up,
Go through the erudite and scholarly judgment authored by the Honorable the Chief Justice of India. I'm in complete agreement with the conclusions arrived at by the Honorable CJI. However, in addition to the conclusions arrived at by the learned Chief Justice, I also arrived at some additional conclusions to which the learned Chief Justice has also agreed. Therefore, I thought necessary to give my separate opinion. In the beginning, I referred to the celebrated speech of Dr. Ambedkar on 25th of November 1949, the Constituent Assembly, wherein he has said that unless we have a social democracy, the political democracy would be of no use. And then he had warned us about the contradictions in the economic and social plane in the country. I referred to the history as to how the term scheduled caste has come in the Constitution from the original depressed classes. I referred to the census report of 1891, the Indian Statutory Commission report of 1930, census report of 1931, the Government of India Act of 1935, and the Government of India Scheduled Caste Order of 1936. I also referred to the repairs in the Constituent Assembly with regard to Article 300A and 300B, which are now Article 341 and 340. I referred to and analyzed the following judgments of the Supreme Court. This court, in the case of M.R. Balaji versus State of Mysore, State of Kerala versus N.M. Thomas, Akhil Bharatiya Shoshit Karmachari Sangh versus Union of India, K.C. Vasant Kumar versus State of Karnataka, Indra Sawhney versus Union of India, M. Nagaraj versus Union of India, Colonel Singh versus Lakshmi Narayan Gupta. I have considered the interplay between Article 14, 15, 16, 46, 35, 338, 341, 342, and 366. Before reading the conclusions, I would read some of the observations that I made in my judgment. I have observed that the basic error that appears to have been committed in EVA Chinaya is that it proceeds on the understanding that Article 341 has to do with the reservation of the seats. As already discussed herein above, Article 341 and 342 are only with regard to identification of the scheduled caste and scheduled tribes. Article 341 and 342, read with clause 24 and 25 of Article 366 of the Constitution, provide that those castes included in the presidential list shall be deemed to be scheduled caste and scheduled tribes for the purpose of the Constitution. However, at the cost of repetition, I reiterated that Article 341 and 342 do not deal with reservation. The provisions of affirmative action, including reservation, the matter of public employment, are contained in Article 16 of the Constitution of India. And I observed that, as already discussed herein above, this court in Indra Sawhney has held that further classification of backward classes into backward and more backward classes is permissible in law. By that corollary, if a state finds that any of the caste, races, tribes, or parts of or groups within the caste, races, or tribes are not adequately represented, should the state be denied its right to make a special provision for them? I find that, as has been observed by this court in various judgments, it is the duty of the state to give preferential treatment to the backward class of citizens who are not adequately represented. If the state, while discharging that duty, finds that certain categories within the scheduled caste and scheduled tribes are not adequately represented, and only the people belonging few of the category are enjoying the entire benefit reserved for scheduled caste and scheduled tribes, can the state be denied its right to give more preferential treatment for such categories? In my view, the answer would be in the negative, since the same would not amount to tinkering with the presentation list. No doubt that if the state decides to provide 100% of the reservation for scheduled caste to one or more categories enlisted in the presidential list in that state to the exclusion of some categories, it may amount to tinkering with that list, because in effect, it would amount to denial of benefit of reservation to those scheduled caste categories which have been excluded. In my view, that would in effect amount to deletion of the said categories from the presidential list notified under Article 341 of the Constitution, which power is exclusively reserved with the Parliament. In my opinion, such exercise would not be permissible. The ground realities cannot be denied. Even amongst the scheduled castes, there are some categories who have received more inhuman treatment for centuries and generations as compared to other categories. The hardships and the backwardness which these categories have suffered historically would differ from category to category. In my view, therefore, merely because they are part of a single or a combined presidential list, it cannot be said that they form a part of a homogeneous group. I therefore have no hesitation in holding that E.V. Chennaiah has been wrongly decided. The concept of subclassification was sought to be attacked on the ground that this would lead to giving reservation for political reasons. It was argued that a political party power to gain political advantage may provide special treatment to a particular class, the scheduled caste. I see no merit in the argument. In a case like the present one, if a classification is made, it will have to be established that the group carved out from the larger group is more disadvantageous and not adequately represented. The result of classification would be to provide more preferential treatment to this more disadvantageous and less represented group. The ultimate object would be to achieve real equality amongst all the subgroups in the larger group. In any case, as has been held by judicial pronouncements, when the state does such an exercise, it will have to be supported by an empirical data. Unless the state or the commission comes to a finding that the group carved out needs special treatment, is more disadvantageous and not adequately represented as compared to the other categories in the group, such a subclassification would not stand the scrutiny of the law. I therefore find that the fear that is posed is not substantiated. I find that the attitude of the categories in the presidential list opposing such a subclassification is that of a person in the general compartment of the train. Firstly, the persons outside the compartment struggle to get into the general compartment. However, once they get inside it, they make every attempt possible to prevent the persons outside such a compartment from entering it. In fact, what the people belonging to the categories who are availing large chunk of reservations and denying a special treatment to the less privileged among them are doing is what the people from the higher caste have done to those people for centuries, as a result of which backward classes were kept away from the mainstream of the society for ages, for no fault of theirs. Only on account of the principle of social and economic justice, as enshrined under the Constitution, they have availed themselves of the benefits of special treatment. However, when the state endeavors to ensure that the said benefit percolates to more underprivileged and less adequately represented, the sections from the scheduled caste who oppose them stand in the shoes of those who oppress them. In M. Nagaraj, the court also applied the principles of quantifiable data and creamy layer even in case of scheduled caste and scheduled tribes. The correctness of the same was considered by General Singh. Though General Singh held that insofar as applicability of quantifiable data on the backwardness insofar as scheduled caste and scheduled tribes is concerned, M. Nagaraj was not correct. However, insofar as the applicability of creamy layer principle even to scheduled caste and scheduled tribe is concerned, it upheld the view taken in Emraj. In doing so, General Singh is basically relying on the judgment of 7-judge bench of this court in N.M. Thomas. The view taken in General Singh has also been approved in Davinder Singh. The correctness of the view taken in General Singh and Davinder Singh is not questioned. However, in the present reference, we are dealing with the question about equality amongst the group of unequals. I find it appropriate to consider the said issue also. The children of the parents from the scheduled caste and scheduled tribe, who on account of benefit of reservation have reached a high position and cease to be socially, economically, and educationally backward, and the children of parents doing manual work in the villages in the same category would defeat the constitutional mandate. However, I may observe that taking into consideration that the Constitution itself recognizes the scheduled caste and scheduled tribe to be the most backward sections of the society, the parameters for exclusion from affirmative action of the persons belonging to this category may not be the same as applicable to other classes. If a person from such a category, by buying the benefit of reservation, achieved a position of a peon or maybe a sweeper, he would continue to belong to a socially, economically, and educationally backward class. At the same time, people from this category, who after having availed the benefits of reservation, have reached the high echelons in life, cannot be considered to be socially, economic, and educationally backward, so as to continue availing the benefit of affirmative action. They have already reached a stage where on their own accord walk out of the special provisions and give way to the deserving and needy. I may again fully refer to the observations of Dr. B.R. Ambedkar. I quote, history shows that where ethics and economics come in conflict, victory is always with economics. Vested interests have never been known to have willingly divested themselves unless there was sufficient force to compel them, unquote. I am therefore of the view that the state must evolve a policy for identifying the creamy layer given to the scheduled caste and scheduled tribes so as to exclude them from the benefit of affirmative action. In my view, only this and this alone can achieve the real equality as enshrined under the Constitution. I read my conclusions. I therefore hold that E.V. Chinnaya, which held that subclassification among the scheduled castes for the purpose of giving more beneficial treatment to a group in the larger group of the scheduled caste, is not permissible, does not lay down a good law. That subclassification among the scheduled castes for giving more beneficial treatment is permissible in law. That while doing so, the state will have to justify that the group for which more beneficial treatment is provided is inadequately represented as compared to other castes in the state list. That while doing so, the state will have to justify the same on the basis of empirical data that the subclass in whose favor such more beneficial treatment is provided is not adequately represented. That however, while providing for subclassification, the state would not be entitled to reserve 100% seats available for scheduled castes in favor of a subclass to the exclusion of other castes in the list. That such a subclassification would be permissible only if there is a reservation for a subclass as well as a larger class. That the finding of M. Nagaraj, Jangal Singh, and Devinder Singh to the effect that creamy layer principle is also applicable to scheduled castes and scheduled tribes lays down the correct position of law. That the criteria for exclusion of the creamy layer from the scheduled caste and scheduled tribe for the purpose of affirmative action would be different from the criteria as applicable to the other backward classes. Before I part with that, my judgment, I place on record my deep appreciation for the valuable assistance rendered by the learned counsels.
Obliged to Lordship.
My opinion is the most lengthy, as it incorporates the exhaustive and well-considered opinions of Honorable the Chief Justice and Brother Justice Roy. However, I have made the conclusions and the opinion shortest. May I read it? I am generally in agreement with the reasons and conclusions arrived at in the opinions of Honorable the Chief Justice and Brother Justice Roy. In particular, that the holding in E.V. Chennaiya that subclassification within scheduled caste was impermissible, does not lay down good law, and stands overruled. Further, any exercise involving subclassification by the state must be supported by empirical data. I am also in agreement with the opinion of Brother Justice Gawai that creamy layer principle is also applicable to scheduled castes and scheduled tribes, and that the criteria for exclusion of creamy layer for the purpose of affirmative action would be different from the criteria as applicable to the other backward classes.
Obliged to Lordship. Justice Sharma. Six views.
Though unanimity and consensus in the opinions expressed by the larger benches on the constitutional matters are desirable for the sake of certainty and strength of the law laid down, I, for one, believe that the dissent for well-chosen reasons would be equally important for an effective adjudication in a democratic functioning of judiciary, which would have a potential to develop the law in future. So I respectfully disagree with the opinions expressed by my esteemed brothers. At the outset, I have not approved the manner in which the three-judge bench had referred the matter to the larger bench without assigning any reason. So I have said that it may be noted that Andhra Pradesh Scheduled Caste Rationalization of Reservation Act 2000 has already been declared unconstitutional by the five-judge bench in E.V. Jenaya as well as in 2005. Similarly, Section 4.5 of the Punjab Scheduled Caste and Backward Classes Act 2006 has also been declared unconstitutional by the division bench of the High Court of Punjab and Haryana, while the judgment dated 29th March 2010, in respect of which present reference is made. Hence, both these acts, as on the date, have been declared unconstitutional. It is further required to be noted that E.V. Chinnaya decided in 2005 was holding the field for about 15 years till five-judge bench in Devinder Singh on the reference made by the three-judge bench further referred the matter to the seven-judge bench in 2020. It is noteworthy that three-judge bench had referred the matters to the larger bench without assigning any reason, much less cogent reason as to why it could not agree with the decision in E.V. Chinnaya delivered by the Constitution bench. The law was settled by the Constitution bench and was prevalent since 15 years was sought to be doubted and unsettled by the three-judge bench by passing a very cryptic and perfunctory order not supported by any reason as quoted herein above. The importance of doctrine of binding precedent in the administration of our judicial system hardly needs to be reiterated. The doctrines of precedents and practices are the core values of our legal system. In series of cases, the constitutional benches of this court have time and again emphasized that when a decision is rendered by this court, it acquires a reliance interest and society organizes itself based on such legal order. When substantial judicial time and resources are spent on the references by the constitution benches, the same should not be further referred to the larger bench by a smaller bench in a casual and cavalier manner and without recording reasons for disagreement. In the instant case, the reference was made by the three-judge bench to the larger bench for revisitation of the earlier decision of constitution bench in E.V. Chinnaya without assigning any reason and in a very casual and cavalier manner, and that too after 15 years of its attaining finality. When a law was settled by the previous bench in E.V. Chinnaya, after considering the previous judgments, including Indra Swani, and after investing substantial judicial time and resources, and when the same had held the field for substantially long period of 15 years, in my opinion, the very reference by the three-judge bench to the larger bench for reconsideration of the decision in E.V. Chinnaya, that too without assigning any reason, was inappropriate and not in consonance with the well-settled doctrines of precedent and stare decisions. Having said that, I have dealt with the constitutional interpretation. It is quite well settled that in interpreting any law, including the Constitution, the text of the provision under Constitution under consideration would be the primary source for discerning the meanings that inhere in the enactment. Sometimes, as a matter of constitutional necessity, it may be prudent to widen the search for the true meaning, purport, and ambit of the provision under consideration. However, one has to bear in mind that no provision, no word, or expression in the Constitution exists in isolation. They are necessarily related to transforming and in turn being transformed by the other provisions, words,